Hi, my name is Vigines and Shankar and my metric number is 254481. Today I'm going to discuss about the aggravating factors and mitigating factors that is confined under criminal procedure code. So let's look about the aggravating factors. Aggravating is defined as after the defense counsel had submitted a plea of mitigation, the prosecutor will submit the aggravating factors for the purpose of pressing for the heavy sentence for the accused. The seriousness of the offense is based on the circumstances of cases. The seriousness of the offense are prerequisite factor in deciding the length of a sentence. There are some aggravating factors such as previous conviction. In previous conviction, the court will consider on the aspect of the previous detention or the past history, background of the background of the accused. In PP vs. Jafar bin Daud, the judge enhanced the sentence from 8 months imprisonment to 18 months imprisonment for possession of drugs, and the accused had 5 previous conviction. So the lot held that whether a convicted person had previous records and admit them as correct, the court must consider whether the offense or offences are committed previously were of a similar nature as the one with the he is presently charged currently. The court must then consider the sentences imposed in the previous conviction of similar offences where he is found, the judge found to be the accused persistent offender for similar type of offences in this type of drug cases. Then it is in the interest of the justice that a deterrent sentences should be passed. And the second factor is about the prevalence or rapidity of offense. The sentence are usually heavy as deterrents for prevalent or rampant offences such as drug offences, kidnapping for ransom, rape, theft, robbery, housebreaking, and firearms. The court will consider weightage and nature of the offences. In the case of PP vs. Tan Heng Hock, the accused was released on good behaviour bond for stealing a car. On appeal, the court considered the rapidity of a car theft and substituted the bond with a deterrent sentence of 18 months. In the case of CRQ versus PP, the Singapore Court of Appeal reduced the death sentence to life imprisonment for kidnapping, as the kidnappers treated the victim kindly and there was no violence. And for the third factor, the status of offender, the position of the accused when he committed the offences, such as an example, the higher ranking officer, he should be example to the public. Instead he had reflect his image as other way, thus the punishment could be severe. In the case of Dato Haji Arun bin Haji Idris and others versus PP, the first accused, then he was a military of Selangor, was sentenced to 6 months imprisonment for forgery and a fine of 15,000 for abatement of a criminal breach of trust. On the appeal, the deputy public prosecutor used his status against him. The federal court enhanced the sentence to 4 years imprisonment on the first charge and 3 years on the second charge to run concurrently, and said the accused should have shown a good example as a leader. On the fourth factor is about the manner of offences is committed, or called as use of force. If the offences are in the terms of brutality, heavy sentences will be imposed and could be ordered for maximum sentences. If the offences is committed with brutality, then heavier sentences will be imposed. In the case of PP vs. Safian bin Abdullah, the mortally wounded victim was brutally strangled with a rope, and hence the maximum sentence imprisonment was passed. In same situation happens in the Joginder case, where in Joginder Singh vs. PP, the accused was in the restaurant business, planted dangerous drug in 2 rival restaurants and plead guilty. But he appealed against the sentence for 2 years imprisonment, and the judge upheld the maximum sentence of 2 years imprisonment because the crime as well was planned and there are several actions that had been taken by the accused. Thus, the plea of first-time offender can't be used as a mitigating factor in this case. And for the fifth factor, it is about the degree of violence, the intention or the level of the violence during the conduct of that particular offence in terms of the harms or damage that had been done during the incident. Where force or violence is used to commit offence, usually a very heavy sentence and whipping will be imposed. In the case of PP vs. PP Safian bin Abdullah and another versus Deputy Public Prosecutor, the judge Wan Yaya imposed the maximum sentence of 14 years imprisonment when the two accused persons in their early 20s pleaded guilty to culpable homicide not amounting to murder. The court will consider the intention of the accused. Thus, it will affect the imprisonment of the accused when the accused plead guilty for the offences that have been done. And for the sixth factor, it is about the effect of deterrent sentence. In criminal deterrence theory, there are two possible applications. The first is that the punishment imposed on individual offenders will deter or prevent that particular offender from committing further crimes. And the second is that the public knowledge that certain offences will be punished as a generalized or standardized deterrence effect which prevents others from committing the crimes. Thus, it explained about the criminal deterrence where there is a deterrence factor that will be imposed for the sentencing when it comes to sentencing the accused for the crime that been committed. And for the seventh factor, it is about the public or international interest. The public interest aspect will be imposed in the cases which have the public views and the sentences is bound to the accused committal of crime and it proves to the public that the law are above all. Example, in the case of Dato Sri Anwar or in the case of Dato Sri Najib, and whoever have popularity in the community or who's the person as the power in the community. So the law must be strict towards them, whether they have popularity or an advanced power other than the community. They are still bound to the laws, and the court will consider the public and international interest when it comes to sentencing. And that's all for the aggravating factors. Okay, now we look into the mitigation factors. The definition of mitigation is defined as production of evidence on mitigating factors that will help the defense in bringing leniency in sentencing. The plea in mitigation should be thrown aside lightly but must be examined and considered equally with the fact presented by the prosecution. Both aspects of the case must be considered in their true perspective so as to strike, if possible, a true balance in the scale of justice when sentencing the accused. There are some mitigating factors. The first is the age of offender. The court will consider the gravity of the offence, the seriousness of the crime, and will consider mitigation factor. If the crime is conducted during early age or first offender, the court will still consider the seriousness of the case. The accused will be released by the good behavior bond by the consideration of the judge in each case. However, in the case of PP vs. Lu Chon Fat, the accused was released on a bond for good behavior under section 294 of the CPC when he pleaded guilty to a charge of possessing heroin. On revision by the High Court, the judge, on the view that the offence was serious and imposed a sentence of imprisonment, even though the accused was aged 20 and first offender. In PP vs. Yap Wat Heng, the court opined that the aim of the punishment of the gravity of the offence should be given priority rather than age. In this case, the learned judge increased the sentence for rape and robbery. For the second factor, it is about the record of the offender. The element of the first offender by the accused will be looked upon, but it is depend on the seriousness of each crime or case. In a case of Abdul Karim vs. R, the court substituted a sentence of 3 months imprisonment with a fine of 400 as the accused was a first offender. And similarly, in PP vs. Makwading, the accused, a member of parliament, was charged with sedition, and the judge said that that being a first offender was a strong mitigating factor, and the accused was released on a good behavior bond. Notwithstanding, a clear record has no effect in drug trafficking cases, as seen in case of PP vs. O Lang Sui, where it was held that the death penalty is mandatory for drug trafficking under Section 39B of the Dangerous Drug Act 1952, even the accused plead guilty. The third factor is about the plea of guilty. A plea of guilty is a strong mitigating factor as it saves time and cost. In case of Sao Su Kim vs. PP, the federal court considered the accused guilty plea even though the offences for the attempt to murder and for unlawful possession of firearms and ammunition were serious offences. In the case of Zaidon Sharif vs. PP, the accused was sentenced to 10 months imprisonment for an offence of possession of cannabis. On the appeal, the High Court substituted the sentence with a fine and laid down following guidelines in relation to sentencing. A plea of guilty is the mitigating factor, is assessing factors or sentence on the main factors to be considered is whether convicted person is first offender before the court pass the sentence. The court is required to call evidence on information on the background, antecedents and character of the convict. Such fact will be basis upon the adequacy or otherwise of the sentence can be reviewed on appeal. The right to impose punishment on the guilty party is absolutely the discretion of the trial court. It will be exercised that the power judicially and will not tolerate even a semblance of encroachment either by the prosecution or the defense. A previous conviction is be taken consideration only if it is a similar nature with the current charge. In the instant case, the accused clean record since in his conviction is in 1986 is a mitigating factor. The rationale of gap principle is that the offender has made an effort to rehabilitate himself. The fourth factor is about the effect on job and other privileges. It may be inferred from the cases that notwithstanding the fact that the accused will lose his position or reputation as a consequence of the conviction and sentence imposed on him, the court are inclined to pass a deterrent sentence in circumstances where the accused abused his position of trust while holding a high office. In the case of Dato' Haji Harun bin Haji Idris vs. PP, the deputy public prosecutor used the title and the status of the accused against him and the sentence was upheld. In the case of PP vs. Vijayaraj, the accused headmaster was sentenced to 1 day imprisonment and a fine for misappropriation of school funds. The judge held that he has disgraced his profession even though he pleaded guilty, but he had demolished a respectable profession which had taken the best years of his life to build the career. The loss of his job and the humiliation suffered by him by this conviction are by themselves a substantial part of his punishment. And the fifth factor is about the cooperation with the police. The conduct of the offender also will be counted during the mitigation period, and if the cooperation mean to be effective, the sentence will be reduced. As we can see in the case of PP vs. Mahindran, the accused pleaded guilty to an alternative charge of possessing the drugs under Section 12, Subsection 2 of the Dangerous Drugs Act 1952 in the High Court, but claimed trial to those original charges respecting trafficking and possession of drugs. His plea in mitigation was heard and deliberately upon wherein Nalini Padmanabhan, the judge, held that the accused ready cooperation with the police from time they stopped him and questioned him until such time as he led them to his house, voluntarily surrendered the subject cannabis is another factor that should be accorded with some mitigating value. This allowed for considerable savings in terms of time taken for the investigation of this offence. And the sixth factor is about the gap principle. The gap between a previous conviction and the prison offence should be viewed as a mitigating factor rather than aggravating factor. The accused to be said had taken a positive step to rehabilitate himself. The longer the gap, the greater the mitigating factor. This can be seen in the case of Zaidun Sharif vs. PP, where the court held that in any event, the fact there has been a 10-year gap in the appellant criminal record had not been duly appreciated by the learned magistrate. The appellant's clean record since his last conviction ought to have operated as a mitigating rather than as aggravating factor. The rationale of a gap principle is that the offender has made effort to rehabilitate himself and it should accordingly operate in his favor. The last factor is about the duration of custody. The court will consider the period of accused was held in custody before the trial, and this mitigation value will be taken into consideration by the judge. The court will also consider the period of accused was held in custody before trial, as in the case of Muharram bin Ansan vs. PP. It became known at the appeal that the appellant was first arrested on September when he was remanded till release on court bail on January. However, this bail was revoked and he was remanded in custody on November 29 till his trial. The learned trial judge in the prison case was misled into thinking that the appellant was under detention since the date the appellant said that he was kept in prison from November 29. Thus, when the learned trial judge imposed the sentence, which was to take effect from November 29, the judge did not appear to know that the appellant had already been remanded for about 3.5 months. Thus, it is the court's view that this period of detention, brief to it may appear, ought to be taken into consideration by the judge for the purpose of passing the sentence. Accordingly, in this case, the sentence was reduced from 6 years to 5 years imprisonment. So these are my discussion about the mitigating factors and aggravating factors. So with that, I end my discussion today. Thank you.